All right, welcome everyone. It is 10:30. We are ready to get started with this end of the third quarter legal webinar. We're talking today about how to do employee terminations correctly. I call this the "You're Fired, Avoiding Legal Claims by Angry Ex-Employees." So thanks everyone for joining us. Please know that this is, we have the chat feature enabled. So if you go to the bottom of your screen, and you will see a little call out box. And if you click on that, it's going to open a column for chatting on the side. That way, if you have any questions as I go along, if I say something that you want to get some more clarification on, go ahead and type your question into the chat box. I've got it open on my screen here, and I'll be watching that closely. So with that, we will go ahead and get started. And we have a couple of important topics today. We're going to do this in 30 minutes, so it might seem like a little bit of a race. But I want to make sure that if there are questions that are relevant to the businesses that you guys are running and managing, go ahead and put, you can either unmute and call out or just put it in that text box in the chat feature and we'll make sure we get them answered. We're going to start off by talking about at-will employment and what that means. We're going to talk about the importance of performance management for our employees and our workers. We're going to talk about termination meetings and the best ways to do those and handle them. And then we're going to wrap up number 4 with severance agreements. So that's kind of the overview for the next 30 minutes. And with that, we'll dive in and get started. So I hope everyone here knows that Utah is what we call an at-will employment state. This is actually the law that is in place for everyone in Utah and everyone else throughout the entire country, except there's one state that is not an at-will state. That is Montana, actually. So one of our almost neighbors here, if you're in Montana, there is not an at-will rule. Essentially, in Utah, what the at-will rule means is that you can fire an employee at any time for any legal reason, with or without notice. That's one side of it. The other side is that employees get to quit their job anytime for any reason, with or without notice. The idea there is that we don't want involuntary servitude, of course. We don't want employees to be stuck with an employer that they don't want to work with. And we don't want businesses stuck with people that they don't want to be working with as well. So the rule gives flexibility to workers and to business owners and business managers to work together when it makes sense and to stop that employment relationship when it doesn't make sense anymore. Okay, so that's the at-will rule. Employees can be fired at any time for any reason and a legal reason, with or without notice. So let's talk about what kind of exceptions there are to this at-will rule. What is an illegal reason or an impermissible reason for firing somebody? And there are a few. Number one is you can't fire an employee for a discriminatory reason. You can't fire them because of the color of their skin, because of their sexual orientation. You can't fire them because they've made a complaint about harassment in the workplace. Those would all be reasons that would get the employer in trouble, and those are exceptions to the at-will employment rule. If there's a contract with a high-level employee, if you, as a business owner, you make a contract with a worker and you say this is a 1-year term of employment, and usually in that kind of a case, there will be language about how does that term end prematurely, but that 1-year term makes it so it's no longer an at-will employment relationship, but it's a contractual relationship. If an employee decides that they need to go and, for example, exercise a legal right like voting, if they were fired for leaving their shift to go vote, that could be an exception to the at-will rule. The employer could get in trouble for firing somebody when they go and vote. If the employee refuses to do something illegal, for example, if a supervisor asks an employee to maybe steal some money or to take funds from a business account and invest them somewhere else that the owner doesn't know about, that could be an illegal action, and terminating the employee for refusing to do any illegal action would also be, that's another exception to the at-will employment rule. So overall, business owners have the right to fire employees at any time for almost any reason, as long as it's not one of those exceptions that we talked about. We have a rather recent Supreme Court case in Utah. It involved 2 Walmart stores. And the employees of Walmart are told that if somebody is shoplifting and you try to stop them and they say something about a weapon, you have to let them go. Just back off, let them go, and let the cops deal with it. In these two stores, the employees didn't follow that rule. They detained the shoplifter. One person had a knife, the other one had a gun. No one was hurt, thankfully, but all of the employees were fired for not following the policy. So that issue went to the Utah Supreme Court, and the Supreme Court said, protecting yourself in the employment situation when you're at work, if you've got to protect yourself and there's no way to back off safely, you have a legal right to protect yourself. And if the employer fires you for protecting yourself, that is a violation of Utah law. Okay, if you have any questions about the at-will employment rule, please type them into the chat feature and we'll get to them. One thing that sometimes comes up when we're talking about at-will employment is this idea of a probationary period. So if any of you in the businesses that you work at have a probationary period in place for your employees, I would strongly recommend that you rethink that policy and get rid of it. The reason is, if we have, say, a 90-day probationary period, which is pretty common, I do see those from time to time, what happens when the probationary period is over? You know, if the employee has been successful, they've stayed on the job, they've done their duties, and within 90 days, everyone seems to be happy with their work, and then they pass that 90-day threshold. What happens then? Do they have some kind of job security? It would seem that way. And so that is why telling an employee that there's this probationary period kind of is contrary to the idea of an at-will employment relationship. So in truth, employees are and really should be at will from day number one until the end of their employment. And it doesn't matter if it's been 30 days or 90 days or 3 years or any other period of time. Employees should always be at-will employees where they can leave at any time and they can be fired at any time for legal reasons. Okay, that is our overview of the at-will employment rule for Utah. Let's talk about performance management. I wanted to discuss this today because it's an issue that comes up so often and it tends to trip up employers. Performance management is the idea that when employees are not performing the way that we expect them to, if they're not doing the things that we're paying them to do, we need to hold them accountable. And so many times businesses will, or owners and managers, supervisors will reach out and they'll say, we need to let somebody go. They've been a terrible performer. They haven't been doing their duties. They always show up late. They're not staying focused. They're spending time on YouTube, all these kinds of performance issues. And we want to fire them. And so I ask the employer, I say, well, you know, do we have it documented? Has this person been talked to? Has it been put into a written performance evaluation? And most of the time, the answer is no, unfortunately. They may say, well, you know, we talked to them, but we didn't document it. Or we'll look at their performance evaluations and we'll see, you know, year after year, meets expectations, or exceeds expectations even. And I get why that happens. It's uncomfortable to sit down with an employee and say, listen, you're not doing a good job. We're thinking about firing you. You really need to get your act together. But when employers don't do that, when the manager is not willing to have those direct conversations with their direct reports and really tell them where they need to improve, that puts the employer in a really tough spot when it gets so bad that it's time to fire the employee for poor performance. So make sure that you're training your managers and your supervisors that when they sit down with their employees, that if there's a problem with performance, it needs to be called out, it needs to be documented, and the employee needs to be told what we expect, you know, what are our reasonable performance expectations? And if you don't meet these expectations, there could be further discipline, including possible termination of employment. Okay, when we're documenting disciplinary actions, it's really important to either do it in writing or to do it like a formal writing that's presented to somebody in a performance evaluation meeting, or do it by email. Email is fantastic. You can confirm the date that it was sent. You can confirm that it actually made it to the person's inbox. Depending on the email system that you use, you might be able to confirm that it was opened and when it was opened. Email documentation about performance expectations is super important and a really easy way to do that. Okay, Lori, great question. Does the employee need to acknowledge? Absolutely not. Whether you're presenting a written performance evaluation form or a disciplinary action form in an actual one-on-one meeting, or whether you're sending an email, there really is no legal reason why the employee needs to sign that document. And granted, if they sign it, sure, it makes it easier to prove that we really did have this meeting with the employee and we really did tell them you need to improve your performance. But there's a better way to get it than just getting a signature on a paper, which is having two people in any kind of a disciplinary action or performance improvement meeting, okay? Always a good idea to have one person who's going to talk and one person who's going to be a witness. They can listen, they can take notes, but it's two representatives from the company. What that does is it avoids a he said, she said situation. So anytime there's a tough conversation that needs to be had, make sure that the business is providing two people and we don't get into the he said, she said situation. But signing the documents or acknowledging the email, not legally necessary. Sure, it's helpful. But if the employee, and this happens often, they get nervous, like, well, I disagree with this. I don't want to sign it. That's okay. You might write under the signature line that signing here does not mean that the employee agrees, but just acknowledges that we met. I see businesses do that from time to time, but usually an employee who's just been told that they're not doing a great job, they usually are not reading the fine print. And even if you explain it to them, they sometimes are nervous enough that they just don't want to sign anything. And that's okay. Don't ever feel like you have to get a signature. It doesn't change anything from the legal perspective. Okay. If you have an employee handbook, make sure that in the employee handbook, there is a disciplinary action policy and a performance evaluation policy. If they're in there, fantastic. If they're not in there, make sure you get them in there. You can reach out to me. You can find one online if you feel like it's a good resource, but put something in your employee handbook that talks about how we're doing performance evaluations and how we're going to handle employee disciplinary actions. And most important on that disciplinary piece of the handbook is to make sure that the language of the policy gives you flexibility. Meaning, I've seen from time to time policies that say we're going to start with a written policy. We're going to start with a verbal warning, and then it kicks up to a written warning, and then it's a final warning, and then it's termination. And that can cause problems sometimes if there's no flexibility built into the policy. It's really important to say in the disciplinary action policy that the employer reserves the right to skip steps as needed or in their sole discretion. That way, somebody who shows up late and they get a tardy, we can do a verbal warning for them. And if it happens again, we can make it a written warning. If somebody gets into a fight in the workplace and punches their boss, we don't want to start with a verbal warning. We want to go right to a final or maybe right to termination. And that flexibility is really important to make sure it's written into your policies in your employee handbook. Okay, Jacob, you got a question here. I feel like the phrase further disciplinary action is hollow. Some of these, what are some examples besides legal disciplinary action, besides termination, that are legal? Okay, I get that. I appreciate expressing that concern, Jacob. Further disciplinary action, I'll tell you why I do like it, is it can be anything from the range of another verbal warning to some kind of a written warning or a final written warning. It can be suspension. It can be a leave of absence with pay or a leave of absence without pay. It could be a demotion. It could be, really, I know every business is different, so there are different ways that you could take disciplinary action against your employees. But I do like language that says there can be further disciplinary action. And if you want to bulk up that language and say, including further written warnings, suspension with or without pay, demotion, or other things like that, you can, of course, add that into the policy. But explaining that there is going to be some kind of further disciplinary action is super important. So thanks for bringing that up, Jacob. All right, let's see, performance management, anything else here? Consistency. Super important for employers to make sure that we treat employees consistently. If we have one employee who's showing up late and we discipline them, we need to make sure that the next employee who shows up late is disciplined in a like manner. What we don't want to have is maybe some group of employees, we always hold them accountable for performance problems. But then we have this one person who's really important to our business, and when they show up late, we just kind of let it slide. That's a problem. What that does is it leads into a potential discrimination case where certain employees are being treated worse and other employees are being treated better. And you look at, well, what's the difference between these employees and those employees? And I've seen it happen a lot of times where the employees that are being held accountable and are being disciplined happen to be the minority employees or the female employees, whereas those who are sort of getting a free pass and are not being held accountable, those are the high performers, or those are the men, or those are the people who go to church with me. Those kinds of different or inconsistent treatment between groups of employees is the fastest way to get a discrimination case landing on your doorstep. So make sure that when you're disciplining employees, that we're doing it consistently, that we're not being more harsh on some employees and easier going on other employees. Okay, so we've got at-will employment covered, we've got performance management and disciplinary action covered. Let's talk about termination meetings. I hinted at this just a minute ago, but let's dive into it a little bit more. When you sit down to fire an employee, it's always important to make sure you've got two company representatives there. Don't ever let it be a one-on-one meeting. Those lead to the he said, she said, and they lead to all kinds of legal problems that keep me busy, and I'd rather spend my time somewhere else. So make sure you've got two employees there representing the business. Before you sit down with that employee for the termination meeting, make sure that you've got a plan of action in place. It's really a good practice to put together a termination notice, something in writing that you're actually going to hand to the employee during that termination meeting. And there's a few reasons why I encourage my clients to do this. Number one is when you sit down to fire an employee, usually it's an uncomfortable situation. Both sides want to get out of that meeting as quickly as possible, right? Nobody likes to be in those kinds of situations. They're tense, they're emotional. Sometimes there's yelling that happens, there's tears that happen all the time. And in that kind of highly charged environment, it's hard to say what it is you plan to say before the meeting began. And so as a business leader or as the owner, make sure you take time to write out the reason why you're letting somebody go. And not only, the reason, explain A, B, and C. We've talked to you about these things. We've documented it as we've gone along. Your performance hasn't gone where we need it to be. And so now we're terminating you. Beyond that, you're also going to want to give them information about benefits. You're going to want to let them know that they have property that they need to return. You can identify that in the letter. It might be keys or a credit card, a laptop, a phone. Make sure you go through all the things that you want them to give back to you, all the things you're going to give to them. You're going to want to describe in that termination notice letter that they are receiving their final wages. Utah has a wage law called the Utah Payment of Wages Act. And what it says in there is that employees, when they are fired, and it's an involuntary termination, their wages are due immediately, is what the law says. Now, if you look back actually a couple of sections earlier, you'll see that immediately is actually defined as within 24 hours. So anytime an employee is terminated and it's an involuntary termination, you need to make sure that either you are ready to hand them their check for their final wages at the termination meeting, or that you get it to them within 24 hours. It is good enough under Utah law to start the process of a direct deposit. The day of the termination, you could make that final deposit that day, or you can send a check in the mail within 24 hours, but you've got to make sure that process of getting the payment to the employee happens either during the termination meeting or within 24 hours after that. Employers who don't follow that rule, and maybe they're waiting for a client to pay before they're going to pay their employee. They got to wait for the money to come in or the invoice to be covered. That's not a legal excuse for waiting on paying somebody. Make sure that you've got everything in place to get the check to the employee, either at the termination meeting or within 24 hours. Okay, Penny, most HR people are of the opinion that we shouldn't state the reasons in writing for termination, thinking we'll come back to bite them. Do I disagree? I do disagree, Penny. So thanks for mentioning that, and I hear that a lot. One of the reasons that people don't like to share the actual detailed reasons for termination, again, is because it's uncomfortable. If you tell the employee, I'm firing you for A, B, and C, the chances of them saying, well, I disagree, I didn't do A, here's why B happened, and C is somebody else's fault. That does happen, but honestly, giving them the real reasons is good for a lot of, giving them the real reasons for termination is actually provides a lot of protection for your business. It can make it difficult for them to claim that they were fired through no fault of their own in their efforts to try to get unemployment insurance benefits. It can establish that there was a legitimate legal reason for firing somebody, or that it wasn't for an illegal reason, which can help you if you're ever served with a discrimination or a harassment complaint. And so, yeah, I get that there's reasons why employees are uncomfortable putting the rationale into the paper, into that termination letter. But lastly, I would say, I think it's important to be clear and to be honest with the employees. So many times employers are like, let's just let them move on and hopefully they'll figure it out someday. But I think that's a disservice to our employees. I think by being really clear with them, like, listen, your attitude sucked here and it didn't fly. And we tried to fix it. We tried to address it with you and you weren't willing to do it. And so we're letting you go. That is going to help them see and perhaps improve their attitude when they go to their next job. So I think it's actually helping the employees by being really clear and honest in the termination meeting about why we're letting them go. Okay, Mark, doesn't providing a specific reason give a plaintiff's attorney fodder to begin challenging? It could. It totally could. But if your reason is the real reason why we're letting them go, then I wouldn't be too worried about what a plaintiff's lawyer might be able to do with that. If we're firing somebody for a legitimate reason and it's not for discrimination, it's not for harassment, it's not retaliatory, there's very little that a plaintiff's employment attorney can do. And I can say that, with this, just this insight that I do plaintiff's employment law from time to time. It's not my primary focus. I do work with employees and help them when they've been wrongfully terminated. And I haven't found that there's some kind of an advantage to having that termination letter unless they were told one thing and the letter says something different. Or if the state was told one thing and the letter says something different, that's when we get into trouble. So as long as the employer is being consistent and they're being honest and they're being direct, I haven't seen any legal disadvantage come from doing that. And in fact, if being honest and direct with the employee that I'm firing you for this reason, if it's a legally problematic reason, then you shouldn't fire them for that. But as long as you're following the law and you're terminating them for a legitimate, non-discriminatory reason, putting that in writing really shouldn't increase any legal exposure for the business. All right, Penny and Mark, thank you for those questions. Sai, what about layoffs for declining revenue and profits? Do we just say that's the reason? Absolutely. That's a totally legitimate reason for letting somebody go. If the business is slow, if customers aren't coming in, if sales aren't happening the way they were last year when we built up our team and we need to let somebody go, or we need to let some people go as a layoff, absolutely that's a reason to put in the document, explain and tell them why. And then in that case, and we'll talk about unemployment insurance in just a minute, but that's a time where the language is going to help them get unemployment benefits because they were being let go through no fault of their own. And we'll talk about whether that makes sense as a business or not. But yeah, if somebody's being let go because business is down, that's totally a good reason to put in the letter. No issues there. Dave Sorensen, thanks for being here, Dave. Let's see. Do we inform them about the reasons for termination if it is without cause or at will? My answer to that is yes, and I'll tell you why. So just this week, down at the BYU Law School, I teach an employment law class, and we had this exact same discussion. The students, or one of the students asked me, they said, what if there is no reason for letting somebody go? What if it's strictly just an at-will termination? And my answer to that was, I don't think that I've really, truly seen that happen in about, 19 years here of practicing employment law. Every time that I've had a client fire somebody, there's been some kind of a reason for it. Even though it's legally allowed that you could just look down the line and say, you know what, today, let's fire somebody. Let's pick that person. We're just going to fire them just because, no reason at all. That's allowed in Utah. It's an at-will state. We can fire anybody for any reason, as long as it's not an illegal reason. We could fire them because they've got a basketball jersey on for the team that we don't like, or we don't like the way they parted their hair that day. But I just have to say, I haven't ever seen somebody be fired for no reason at all. I don't think it happens. If that's the case, I probably recommend in that situation to not say, in the termination letter, you're fired for no reason at all. But most of the time we fire people because business is down, because they're not performing, or some other legitimate reason. And there's really no legal risk. And I think there's a lot of legal protection for being fair, for being honest, and being direct in those termination meetings and in that termination letter. All right. Okay, I'll keep watching for any other questions there. Let's go to severance agreements. Man, we've got 6 minutes. I cannot believe how fast these 30-minute things go, but I appreciate y'all being here. Okay. Severance agreements. A severance agreement is a contract between the departing employee and the business. And in its most basic terms, what we're doing is we're saying, we're going to pay you some money and you promise not to sue us. That's the contractual nature of the agreement, okay? There are restrictions on what we can actually require employees to agree to in a severance agreement. We can ask them to agree to give up all of their legal claims to sue us or to bring a complaint for any kind of money. So they can waive an age discrimination claim, a race discrimination, a harassment, a retaliation. They can waive all those claims, and we can immunize our business so that we pay them, say, $1,000. They sign the agreement. We can know that there's not going to be a legal claim where we're going to end up having to pay them more than that $1,000 that we already paid them. Now, a number of years ago, the federal EEOC, which is the agency that deals with workplace discrimination, harassment, retaliation cases, they started pushing really hard on this issue of waiving the ability to go to the government agency and complain about the workplace. And we've had a number of court cases that have addressed this over the years. And what it's come down to today is that an employee can waive their ability to sue and get any more money. What they cannot waive is the ability to just make a complaint. And if we do a severance agreement and somebody waives their ability to sue us and get any more money, in every case that I've done this, literally every case for 19 years, that employee has never come back with a complaint or a lawsuit. But theoretically, they could still go to the EEOC or the Utah Labor Commission and say, I don't work for this person anymore, but I think that there's a lot of harassment going on in the workplace. You should go and investigate them. Theoretically, they can still do that. The ability to complain to a government agency cannot be waived. The other things that come up from time to time that cannot be waived is the ability to file a workers' compensation injury claim and the ability to apply for unemployment insurance. So aside from those, most every other kind of claim that an employee could make to cause problems for a business can all be waived by signing a severance agreement and paying them a severance payment. Okay, we've got some questions here. Eric, I recently had an employee text me back saying they were going to step back from our company and backed out of working a shift. Can I consider that a resignation? Interesting question. I would first recommend let's chat about that afterwards, because this is a fact-specific situation that you're actually dealing with right now. One thing that you're going to want to keep in mind is the consistency that we talked about before. Have you had other employees dealing with this, like doing this kind of thing before, stepping out, and whether or not you counted that as a resignation or not? But because, at the beginning of the call, we talked about at-will employment. If you decide that, we can't have people just stepping back from a shift, if we're going to count it as an absence and we're going to hold that against them and then perhaps terminate them based on our attendance policy. You could certainly do that, but let's dive into those facts a little bit together after the call. Kathy, how important is the language that is used in a termination, such as you are being terminated for fill in the blank, or you're being laid off due to a reduction in force? The language in a severance agreement is super important. Just like the language in a termination letter that we might give somebody when they're being fired. We want to make sure it's accurate, it's concise, it's truthful, and that it's direct. As long as we're doing that and the language is really saying what we need it to say, then there shouldn't be any legal risk there. But it is important to get it right. It's important to review it with your team, review it with your coworker, review it with your attorney, but make sure that the language you're using in the severance agreement, in a termination agreement, is accurate, it's direct, it's concise, it's truthful. Okay, a couple other things about severance agreements. If you're going to let somebody go who's 40 years old or older, there are specific rules. The federal government decided that anyone, once they get 40 years old and older, they need at least 21 days to think about their severance agreement. And then after they decide to sign it, they need another 7 days to change their mind if they want to. So you got to make sure if somebody's under 40 years old, you don't have to worry about this 21-day consideration period. 7-day revocation period. But once they hit 40, if you want them to waive their age discrimination claims, got to give them 21 days to think about it and 7 days to change their mind. Make sure that your severance agreements have language for confidentiality, return of company property, and make sure there's language in there that if they ever challenge it, or if we have to challenge it because they're breaching the agreement, that the winning side gets their attorney's fees paid by the other side. Super important to put that in there to make sure that if they breach the contract and you have to go after them, it's not going to cost you anything, but that money's going to come from the party who breached the contract. Okay, we are right at the top of the hour, 11 o'clock. Thanks everyone for being here. We have recorded this conversation, so this webinar, so if you'd like a copy, shoot me an email, I'll get it over to you. Thanks for your questions, everyone. So good to see y'all and have a fantastic Friday afternoon. Thanks, everyone.